have 2A now in front of me, yes.
Can you read that, please?
The state fire marshal, the state fire marshal's authorized officers, or the fire chief upon complaint, whenever a state fire marshal, such authorized officers or fire chief shall deem it necessary, may inspect all buildings, excluding single-family dwellings or multi-unit dwelling units containing 2 units, and premise within their jurisdiction.
That's far enough.
No, I would prefer that you read the whole sentence.
And if consent for such inspection is denied or unobtainable, may obtain an administrative inspection warrant under RSA 595-B.
So it's your understanding then that as the fire chief, you are not authorized to inspect what are classified as single-family and multi-unit dwellings containing 2 units?
Correct.
How was 75 Leverett Street classified at the time of the raid?
The inspection took place at a building that was registered as a duplex, 1 and 2 family home.
So, were you under orders from anyone to participate in that raid?
Orders from my fire chief, you mean, or?
Yeah, I was wondering if you did it on your own volition as one of the fire
No.
chiefs, or you were ordered to do so?
No, I'm appointed as the fire prevention officer. We obtained information from another department agency, and we joined over a co-inspection of the property.
So did anyone ask you to participate in the inspection?
Yes,
Who was that?
that was what I call the building department, code enforcement.
So was it Fred Parsells?
He was the lead for the housing inspection, yes.
Would you have been able to say no?
Probably not with the evidence that was presented to us.
Even though, as you already pointed out, the building was classified as a single-family.
Right, but as evidence from them was given to us, it didn't look like that was the use anymore.
Are you able to make a legal conclusion like that?
Yes, after an inspection is
After the
conducted.
inspection, but not prior to.
No, we wouldn't have a basis for that opinion at that
So
time.
just to be clear, you're not able to make that legal conclusion until after the inspection has happened.
Yes,
So therefore, how could you have participated in an inspection on a property that was legally determined at that time, as you've already admitted, to be a single-family dwelling?
Objection was legally determined at that time, Your Honor. The whole purpose of the administrative inspection warrant was to allow the fire department to affirmatively dispel the question as to whether the use had been changed.
So, I mean, you're not seriously arguing here, Mr. Freeman, that if you just call something a horse, it's a horse even though it's an elephant?
I'm not sure I understand your question.
Well, I mean, you can call it a single-family property, but if it's really something else, nobody can inspect it because you call it a single-family residence?
Well, no,
Is that-
it's not me calling it that, it's the city's,
Well, okay, but it's
definition.
basing it on, I presume, what somebody who owned the property told the city about how it's being used.
Well, as I understand it, it's always been classified as a single-family dwelling, and that classification has never been changed. The point that I'm trying to clarify here is that at the time they conducted this inspection, he did not have statutory authorization to be a part of that because it had not been yet determined to be something besides a single-family dwelling. If it had been determined to be something different, then perhaps he would have had the ability to inspect. And that's why I'm saying
With all due respect, Mr. Freeman, that's why you have the court involved. The evidence that would form the basis for whether or not an inspection warrant could be granted was presented to the court, and rightly or wrongly, I guess that's a determination I'm going to have to make, rightly or wrongly, that evidence either rose to the level of sufficiency for issuing the warrant or not. I think people ask police officers, you know, in this case the fire officer, ask for warrants all the time. Some are granted, some aren't. It was the court's determination that on the basis of the information that was provided, at least, the warrant was justified, and so it was issued.
Yeah, I follow what you're saying there. The point of clarification I would like to make, though, is that as Mr. Parsells testified, they came with what they claim is probable cause about a lodging house being operated. In the objection recently filed by Mr. Mullins, he says that they wanted to inspect the property to see if it was a lodging house and if there were any violations of the fire code. If it were a lodging house, it's never been alleged to be, they never changed the legal status to a lodging house. I've never been charged with having a lodging house.
Your Honor, we're getting into the second phase of this discussion.
But they're
as to-
trying to fix it.
with all due respect, with respect to whether or not the zoning administrator had hold of the lodging house complaint. That's different than the fire code issues.
But without the change from the single-family dwelling status, he is not authorized to inspect. It's always been a single-family dwelling. Had they wanted to say it was a lodging house after inspecting it, they could have made that claim. But they have no evidence for that, otherwise they would have brought that charge. And at that point, had they actually changed the status, then perhaps he would have been legally authorized by statutes or by a judge to be able to come in and do that. But they never changed the status.
Well, the only thing we're looking at this point, Mr. Freeman, is whether or not the warrant that was issued was based on sufficient evidence to do that. What happened after they got in there is for further evidence to be introduced, but
Right.
at this point, all we're talking about is the sufficiency of the warrant.
Right, what I'm suggesting is that the portion of the warrant authorizing the fire inspection was the part that was inappropriately issued, because it had not, the
Well,
status hadn't
I
changed.
understand that's your argument, yes.
Okay. Let me see if I've got any more questions for Mr. LeFreniere. So just to go back to where we were, when Fred Parsells came to you and told you about this situation, would you have had the ability to tell him, no, that seems inappropriate, I don't want to participate in that?
What was presented to us looked like a violation. It was a possible change of use of the structure, and that's what we were trying to ascertain. So no, at that point, I would not have been able to walk away from it.
Is it
I would have
your,
to follow up on it.
is it your task as a fire chief to ascertain whether the change of use has occurred, or is that the zoning enforcement?
It's probably a little bit of both, but we have in the fire code a change of use. Because once a structure changes its use, we have to review it for fire code application.
Of course, at the time that you were presented this, there wasn't enough evidence to actually change the use of the structure. Right?
Objection, Your Honor, the court understands.
I understand the issue here, Mr. Freeman.
Okay, as previous with the last witness, I still, if this trial goes on, I'd still like to ask some other questions. No further questions on this matter?
Well, I do, Your Honor. Unfortunately, it's a bit out of sequence. What I would prefer to do with the court's indulgence is to recall Mr. LeFreniere after we finish with the zoning administrator, because that's how we got into this process. And I can explain to the court, Mr. Freeman, the decision of the zoning administrator, but Captain LeFreniere still has an independent obligation. We need to walk through it now and bring the zoning administrator back up, and I guess I'm a little...
Well, have we introduced all the evidence you want to introduce?
Oh, yes,
on
Your Honor.
Sufficiency.
Yes, Your Honor, I apologize for that, yes.
Okay.
Yes.
So, do you have another witness of any sort you want to introduce on that issue?
No, Your Honor.
Okay. Any other questions for
No, thanks.
the officer about that issue?
Not on that issue.
Okay, thank you, sir.
Thank you.
Okay, so we're at the point of determining whether or not the issuance of the warrant was sufficient.
That's now submitted to the court for its determination as far as the state suit.
Okay. Well, what I need to do at this point, before ruling on that, is look at pages, whatever it was, 4 through 22, which I have not seen previous today. So I think to go farther than this today really doesn't make any sense. I think I need to review that, make an order about the sufficiency of the warrant, and then, depending on how that goes, we either proceed or we don't.
I agree.
up to the court.
So I'm gonna take that issue about the sufficiency of the warrant under advisement.
Thank you.
Based on the written order that I make about that, we'll either proceed further or we won't.
I guess you do have my motion here, which is basically my memorandum on that,
Yes.
on that issue. And can you please take under advisement that I will be traveling some more within the next few weeks, so my schedule will be fairly limited in the month of June. So as far as a follow-up hearing, I would prefer it be early July is fine, but sometime in July would be.
I don't think there'll be a problem with that, Mr.
Okay.
Freeman.
Thank you, sir. Appreciate it.
If you want to please recall as well, Mr. Freeman did submit that motion to dismiss based upon the constitutional provision, and I believe the court was moved on that yet.
I will also take a look at that as well.
Thank you, Your Honor.
All right, thank you.
Court non-recess.
Tomorrow. Whatever that was, you would email. Your email.
It goes right by my schedule on Monday. Whatever comes.